Thanks for the warnings. On behalf of our chair, Warren Lindsay, our chair-elect, Jason Blank of the Criminal Law Section, mute yourselves, please. There are a bunch of you in the room. We've got 134 people on the Zoom. Jenny Dormany, our program administrator, without whom nothing great happens, our CLE committee, our membership committee, and our juvenile committee, and our community of over 2,100 prosecutors, defenders, public and private, and judges and legal educators. Welcome to this special CLE, the ABCs of juvenile delinquency. I am Scott Fingerhut, your CLE chair. First, 5 quick housekeeping items, okay? Number 1, we're all here on Zoom, right? So your videos are off. You've muted yourselves. Thank you very much. If you want to do this, if you go to your video settings and click hide all non-video participants, then you won't have to look at everyone's black boxes. All right, so if you click on the little arrow next to your stop video icon beneath the screen that shows you, there it is, hide all non-video participants. If you want to be in speaker view or gallery view, that's your choice. You'll hear a little bit more about that in the future. In your video settings, if you have not enabled your HD, I recommend you do that as well. 2, if we happen to get Zoom bombed, not very likely since we're pretty much password protected, but if it does happen, I guess depending on the severity of the bombing, we may just fade to black and then just log right back on, and we'll pick up where we left off. 3, if you have any questions for our program chair or any of the participants, feel free to put them in the chat, which we have activated. That's what the chat is for. Or you can send emails to me at hsfpa@aol.com. Yes, it's AOL. I'm sorry. Here with my BlackBerry. Or you could email Jenny at jdormany with a D at floridabar.org if you prefer to be anonymous or just send your question that way. 4, our CLE course number, which I will repeat at the end, is 4193. 4193. The video link to this presentation and the accreditation form will all be provided by Jenny once we are done. And 5th and finally, before introducing our main man of the hour, the criminal law section. Join us if you are not a member. It's literally only $25 a year. And get involved if you're a member of the section and have not been very much involved to date. You get a lot. It's a chance for you to give back a lot to impact your criminal justice system and make a qualitative and quantitative difference in your life and the lives of others. floridabarcls.org, floridabarcls.org. Okay. None of this is possible today without Judge Thomas Palermo. His bio was provided to you, so you can certainly read it in depth. I will tell you, he's a circuit judge in the 13th Judicial Circuit, currently assigned to the Juvenile Division, and he's basically everything good you'd want in a human being. He's clerked, he's been a state prosecutor, he was a highly decorated federal prosecutor, student body president at American, cum laude at FSU, got his LLM in London at King's College. For the love of God, he's an assistant cub master in the Boy Scouts. How could you not love this man? He's Tampa born and raised, and we are here today because of his investment in our children, in the justice that they deserve, and how we, as the lawyers meting out that justice, can do better for them. So, without further ado, let's get the program going. Judge Palermo, the Zoom is yours.
Well, Thank you very much, Scott. I appreciate the introduction. It's certainly more than I deserve. I am here today to welcome you to the Juvenile Delinquency ABCs program. This program is the kickoff, the teaser for a longer program the criminal law section is going to be putting on. And so I'm very excited to be here with you today. And we're going to try to do things a little bit differently. We've got a rock star group of panelists who are going to be speaking to you. But before we get to them, we're going to try to turn this away from a standard panelist open mic presentation. And we're going to start today with a video. We put together a pre-recorded segment. It lasts about 34 minutes. And we're going to use that to frame the dialogue today. The purpose of the program is to help you and anyone who watches this later to increase your competence in the delinquency courtrooms and to increase your confidence. The deeper dive that the criminal law section is going to put on is really going to go deeper into the weeds about how to get and to do better in a delinquency courtroom. Our job today, our goal today, is to really introduce you to some of the bigger concepts and to help you avoid some of the more common pitfalls when you walk into a delinquency courtroom for the first time, or if you've just been there a million times, to hear about the different things that are happening across the state of Florida and how we are going to, I hope, help everyone to do better representing the kids of the state of Florida. So I am joined today by my co-host, Patricia Dawson. Pat is one of my friends. We've been friends for a very long time. We were both prosecutors together at the state attorney's office. And Pat's the co-moderator. Pat, you may know her if you live in the Bay Area from her television appearances, usually on Fox 13 or other local TV channels. But she was an extremely serious prosecutor, prosecuting homicides, sexual battery offenses, racketeering offenses, dating violence offenses. She went to Florida A&M University and FSU College of Law. She's on a number of Florida bar committees, including the criminal law section with me. And she's also a volunteer, giving her time to places like the Board of Sickle Cell Association of Hillsborough County, where she serves as the chair. Pat's my friend, and also she will be one of the actors, the stars of the video you all are about to see. So Pat has about 26 years of experience, and I asked her to play a rookie who didn't know what she was doing. So we'll see how the acting went. So without further ado, Pat, will you say hello to everybody for me? All right. Well, there's Patricia Dawson, and you are about to see her again in about 2 seconds. So everybody, welcome to the ABCs of Delinquency.
Well, your payment has gone through. Thank you very much for hiring me to represent your child. I'll get right back with you when there's more information that I need to advise you of. Thank you again. All right. Bye-bye. Oh, I need to phone a friend. I've never done a juvenile case ever. I know who to call.
Good morning, this is Tony Julian.
Hey, Tony, how you doing?
Hey, Pat, what's going on?
Oh my God, Julian, I have been reading the rules of criminal procedure, and I have taken on 2 juvenile cases, and I cannot...
Wait. You have 2 juvenile delinquent cases?
I know.
Okay, I've known you 17 years. You've never done juvenile court. What's going on?
COVID-19, I got to stay in business.
Okay. Okay, well first, stop reading, for your juvenile clients, stop reading the rules of criminal procedure. You're now going to be in unified family court. It's different than being in criminal court. If you're not familiar with Chapter 985, you need to familiarize yourself with Chapter 985. When's your first court hearing?
The case is tomorrow.
Okay. So get a pen and a piece of paper. I'm going to tell you a few things that you should know before you go in front of the Unified Family Court judge, okay? Okay, first, there's terminology that is going to be different. You're used to criminal informations being filed or criminal indictments, but in juvenile court, if the state decides to file a case against a juvenile, it's going to be a petition, okay? So that's what you should refer to. Also, don't talk about the child, don't ever refer to the child that you're representing as a criminal or being in a criminal court. The child is just a juvenile. He's a child. At some point, if he's found guilty by a court of having committed a criminal offense, he's not going to be called a criminal. He will just be adjudged a delinquent child, okay? So right now, he's just a child. If he's found guilty, he becomes a delinquent child, okay? But he's never going to be, called or referred to as a criminal. A few other differences are your child, the whole purpose of the Unified Family Court is not to punish the child. There's never going to be a trial. There will be an adjudicatory hearing. They don't call it a non-jury trial. They don't call it a jury trial. They call it an adjudicatory hearing. Also, the child will never be sentenced, but if he's found guilty, there will be a disposition hearing, okay? And the whole purpose of the Unified Family Court and dealing with the juvenile is not to punish the child like they would if he were an adult. It is to rehabilitate the child. The sanctions will be geared by the court to encourage the child to make better choices and not to, fall into the trap of becoming a criminal, okay? So that's a few of the differences. Also,
I'm sorry. Can I ask you a question real quick?
Of course.
Because one of the reasons I was looking in the criminal rules of procedure is, and I hope this doesn't sound dumb, but I couldn't find anything on bond.
Okay, because there are no bonds. Like tomorrow morning at the detention hearing, they're going to review the allegations against the child. They're going to review the child's age, the child's history, criminal history, if anything, but there will be no bond. And your objective tomorrow, I'm not going to talk all about the detention hearing because I've got somebody else you should call to discuss that, but there will be no bond. The penalty might be if the child doesn't get released tomorrow, the child may have to stay at like the juvenile detention center, so you're going to have to deal with that issue. But it's very important that, how many cases do you have tomorrow morning?
I have two.
Okay, well, it's very important that you have at least a parent present for both children tomorrow. What other question did you have?
Well, one of my questions is, one of my cases is a robbery with a firearm, and my client is 17 years old. He's a good kid. He's never been in trouble before. He's a straight-A student. And obviously, since I do, criminal court, I know juveniles are put in criminal court. And I'm wondering, what do I need to do to keep them, or is there anything I can do to keep him in juvenile court?
Okay, if the 17-year-old does not have a criminal history, if he's got good parents who will monitor the child's behavior, you should talk with the chief of the juvenile division at the state attorney's office to encourage the chief to keep to file a petition and to keep the child in juvenile court. That's what you should do. But you're not going to accomplish that today. You need to get ready for the detention hearing, and I really think you should. Do you know Dominique?
Yes.
Okay, good. Look, why don't you give her a call? I'll help you as much as I can. You can call me back if you have any follow-up questions, but you should give her a call to discuss the detention hearing tomorrow morning. She's been doing a lot more of them than I have lately. Okay?
Thank you, Julia, and thank you for not. I don't want to go in there looking at all.
Oh, no. You won't. You're professional, but if you use the Unified Family Court and the Juvenile Court lingo, the judge will probably be less inclined to sneer at you. Okay? Okay.
All right, I'll give Dominique a
It's
call.
great hearing from you. Talk to you later. Okay.
All right.
Bye-bye.
Okay, so Tony said call Dominique. Here we go.
This is Dominique Sellerin.
Hey, Dominique, this is Pat Dawson. How you doing?
Good. How are you?
Oh my God, I'm a little frazzled. I have just taken on 2 juvenile cases, and you know I don't do juvenile.
Oh, yes, I know. Oh, my goodness.
So Tony told me to give you a call, and you'll be able to walk me through detention.
So, you know what? I have the perfect person for you for detentions, but I think before we get there, it may be helpful just for you to have a better understanding of the juvenile justice system before you go to detentions.
Okay, I have my pen and my paper. I'm ready to take all the knowledge you can give me.
So, I mean, one of the biggest things I think is that the goal of the juvenile justice system is rehabilitation rather than punitive. So, that's something that you want to make sure that you're always aware of and that you're always kind of having in the back of your mind. So we have things like diversion programs for children to try to keep them out of the system rather than punishing them, although, that's weighed against public safety still.
Okay, so there are diversion programs. I understand from when I'm in felony court and I go to different counties, every county has different names for everything. Like Dade County has a different name than Hillsborough County. In this case, obviously I'm calling you because it's in Hillsborough County. What's the diversion program name in Hillsborough County?
So we have a few diversion programs here. There's one that is it's pre-arrest, so me and you, we won't even see those types of cases. Those just get disposed of beforehand. One of the biggest programs is what's called a Walker Plan. Essentially what happens is the child enters into a plea to the charges, but instead of actually going through with it, the plea is put in abeyance, and the child completes conditions that are similar to what they would do if they were on probation. So they would do like community service hours, they would do maybe a letter of apology or just observing court, and then from there, once they complete those conditions, their case is dismissed. So that's one of the big diversion programs that we have here in Hillsborough County.
Okay. All right. One of my concerns is that I have a robbery with a firearm, a first-time offender. He's 17 years old. He's a good kid. He lives with his parents, and I really need him to stay in juvenile court. What do I need to do?
Right. That's definitely a tough situation because he is 17 and it's a firearm charge. So the state does have the ability to file an information in adult court rather than filing a petition and keeping it in the juvenile system. You really want to make sure that you are reaching out to the state attorney early. So, early intervention is really, really important. And you just want to talk to them. You want to make sure, you have to appreciate the seriousness of the charge and the fact that it is a firearm case, but you also want to make sure that you're presenting some mitigation. So, how the child does in school. You want to really emphasize that this is a first-time offense, no prior record, just things of that nature to try to convince them just to keep it at least in the juvenile system, because we certainly don't want a 17-year-old with a felony charge going out into the world.
Okay, thank you very much. I appreciate that.
Of course.
We'll talk to the state.
Yeah, and since you mentioned, detention hearings, and so like I said, the perfect person, your go-to girl, Amanda Mendez, she will give you the rundown on detention. So she'll make sure that you're using all the right terminology, you're making the right arguments, everything. So make sure that you call her for your detention hearing.
Yeah, I know Amanda. I'll give Amanda a call. And thanks so much for all your help.
Of course. Let me know if you have any other questions.
I will. You have a good day.
You too.
Thanks. Bye-bye.
Bye.
All right, Amanda.
Hello, Attorney Mendez.
Hey, Amanda, this is Pat Dawson. How you doing?
Hi, Pat. Long time no chat. How are you? Juvenile. Okay, let me put my phone on speakerphone so we can talk more about it. All right, so you're taking juvenile cases.
Yes, I just finished talking with Dominique, and she told me to give you a call, that you'll be able to help me with the detention hearings that I have coming up. I have a domestic violence case, never been in trouble before. The alleged victim is the mother. And I also have a robbery with a firearm, 17-year-old male, straight-A student, captain of the football team, and again, never been in trouble before. Help me, please.
I have you covered. First thing I want to point your direction is going to be to statute 985.255. That's important because that covers the criteria for detention hearings. Now, unlike first appearance, where you're arguing for a monetary bond, with juvenile, you will be getting a copy of the criminal affidavit report along with what is called a risk assessment instrument. Now, that's a standardized tool that's generated by the Department of Juvenile Justice, and it scores a range of points based on the child's history and the current offense presented to the court.
That's important because once you get the copy of the criminal affidavit report
and you get the risk assessment, that's going to generate a range of points. And those points are going to determine the type of detention the child will undergo after the hearing. Now, you did mention that there was a domestic violence charge and that the alleged victim was the mom. Is that correct?
Yes.
Okay. Well, that type of charge on a misdemeanor typically would score with no history, a home detention or an outright release. The issue is that the state is going to argue for a no contact order. So what happens is the child will not be able to go back home with mom. So it's going to be up to you to try to see if you can find another relative that the child can stay with. If not, the child is likely to go to respite care, even if the child does not score a detention. Now, don't be alarmed. You do have time. If the child is transferred to a respite care, which in Hillsborough County we have Lake Magdalene, you have the ability to continue to look for any relative that the child may have. And once you locate a parent or a relative, you can go back to the court for a detention review. At that point, you can ask that the child be transferred over to another relative for the remainder of the detention. Does that make sense?
Yes, it does.
Great. In addition, you did mention the robbery with a firearm. I'm going to be honest with you, Pat. That's going to be tough because that offense alone is going to score detention. So this is regardless of what the child's history is. So the best bet you have in getting the child released is going to be arguing probable cause based off of the criminal affidavit report. Now, if the judge rules in your favor, then the child will be scoring an outright release. However, if the judge does find that there is probable cause, then the child is likely to score secure detention. You can present to the court mitigating information and ask the court to consider using their discretion in scoring downward, but I'm going to be honest, that's going to be very difficult because the court has to also consider the nature of the offense and the public at large.
Okay.
Now, if you have any additional questions, feel free to give me a call. I can even text me in the morning if you'd like, and I'm here to support you.
Oh, this has been really helpful, and I do feel like I'm prepared. And if I need you, I will give you a call.
Okay. Well, thank you so much. It was good hearing from you. Good luck.
Oh, thank you, and have a lovely day.
Thanks.
All right. Good morning, Mr. Scurry. How are you this morning?
I'm good, Jan. How about yourself?
Good. What do we got?
This morning, the first youth on the docket, Parlor Trouble. The risk assessment, she scores 4 points for a misdemeanor battery, touch or strike. The victim is youth's mother. The mother reported the need of further protection. She also reported minor injuries to her face. The youth was placed in secure detention, even though she scores 4 points for release.
All right. Thank you, Mr. Scurry. Who's number two?
Number 2 is Mark Foster. The youth was charged with robbery with a firearm. On the risk assessment, he scores 17 points, which calls for secure detention.
All right. Thank you, Mr. Scurry. I appreciate it. All right. Madam Clerk, are we ready to get rolling?
Yes.
All right. Why don't you call our first case?
First case on the docket, Parlor Trouble, case number 20 CJ 9187A.
All right, good morning. This is the juvenile detention hearings. I am Circuit Judge Thomas Palermo, and we're starting today with the case of Ms. Trouble. Can I get appearances, please?
Yes, good morning. Travis Coy for the state.
Good morning, Attorney Patricia Dawson for Ms. Trouble.
All right, good morning, counsel. I also note that Ms. Trouble is present at the Department of Juvenile Justice Detention Facility and present by video this morning. It also appears that her mother is present by video as well. Is that correct?
Yes.
Have we had an opportunity to confirm that she's been read and reviewed her rights in the charges, Ms. Dawson?
Yes, Your Honor, I had an opportunity to speak with Ms. Trouble.
All right. So this morning, I've reviewed the criminal report affidavit. Counsel, have you all had the opportunity to review the criminal report affidavit in the case?
Yes.
Yes, Your Honor.
In my review of it, I do find probable cause. Does anyone have any objections to my finding probable cause?
Your Honor, I do, because obviously Ms. Trouble maintained her innocence and that she did not commit a battery.
All right. Well, I understand she'll be persisting in her plea of not delinquent down the road, but for the purpose of the detention hearing today, there are at least sufficient facts in the criminal report affidavit to suggest to the court that I should continue to persist in my finding of probable cause. Having found probable cause, counsel, have you all had the opportunity to review the detention risk assessment instrument, the DRE?
Yes, I have.
Yes, I have, Your Honor.
And Mr. Scurry, who's present here in the courtroom, Mr. Scurry, what does the DRE calculation call for in this case?
It calls for release.
All right. Counsel, does anyone have any objection to the DRE calculation in this case?
No.
All right, hearing no objections, I will fix the DRE calculation at this time. My understanding is that her mother is present. Mr. Coy, do you know whether or not the mother wishes to have contact with her daughter at this time?
Actually, yes, I do, Judge. Before we actually proceeded, I had an opportunity to speak with the mother. The mother has advised me that she is fearful for her life, and she does not want her daughter, the juvenile in this case, to reside with her anymore.
All right. Ms. Dawson, do we know if we have any alternate placements? Right now, the available respite placement would be Lake Magdalene, I believe. Do you know if there's any alternate placement options if she can't return home?
No, Your Honor. My client wished to return home. Obviously, since she did not commit this crime and she is not a threat to her mother, and she scores release, she has a right to be released to her home.
Well, she can't return home with a motoring no contact at this time. So if the mother in this case is present, my understanding is that she does not want to speak. Is that correct, Mr. Coy?
That is correct, Judge. She relayed her intentions with me.
So
Yeah, I think that if you order no violent contact, that should be sufficient, and my client could at least return home.
Well, I've looked at the criminal report affidavit. Let me ask Mr. Coy, what's the state's position with respect to contact?
Judge, based upon my conversation with the victim in this case, she has made abundantly clear that she does not want to have contact with the juvenile, specifically to the point where she does not even want her to reside with her anymore.
So have we explored, either the state or the defense, have either of you explored any respite care options? Are there any aunts, relatives, or anyone else who might be available?
Judge, with speaking with the victim in this case, from my understanding, there is no other close relative that would be able to take on the juvenile.
Your Honor, my client has no priors. This is her first incident with the court system. For you to send her to Lake Magdalene, that mentally would devastate my client. And taking her out of her environment with her mother at her home, her school, I think that is drastically affect my client, and she has not been found guilty of anything, and she's being punished for something she did not do. I don't see why an order of no violent contact would not suffice and allow my client, who only scores 4 points, to return home.
Right now, as I understand it, the victim is not comfortable with her returning and is requesting no contact at all, not a no violent contact. What I'm willing to do though, counsel, I have to order some sort of respite care in a scenario where a child does not have, cannot return to her own home and that there's no obvious alternate placement. So right now, it sounds like Lake Magdalene is our only option. What I'm willing to do though is to place this on the detention review docket next week, and we can follow up to see how your client is doing and to check in and see if the situation has changed with respect to an appropriate placement for her, and to try to give you some more time to see if maybe there are any alternate options that would be better than Lake Magdalene. So I appreciate the forceful advocacy on the part of your client. But right now, I think we're going to have to start with respite care, and I will set a detention review 1 week from today for us to kind of go through and to see if there's anything else that's developed, if there are any alternate placements, if there have been any changes between this week and next week that might change where we can place her. That being said, having reviewed the DRE and we're calling for only 4 points, I am going to order her released, but I will make the finding that the child is in need of respite care, that she can't return home, and for this point, for right now, I'm ordering that she have no contact with her mother. Counsel, is there anything else that we need to cover this morning other than the arraignment date?
Well, Your Honor, I would like to place my objection on the record that in the sense that no violent contact would suffice, and you are punishing my client for something that she has not been rude as a delinquent, or that the act occurred, and you are in a sense holding my client. You may say the word release, but you are holding her because she cannot return to the only place that is home to her.
All right, your objection is noted for the record. I will say the purpose of the delinquency system is rehabilitation, not punishment, unlike the criminal system. And our goal here is to try to work with you and your client and the state to try to get her back on track. So I appreciate the concerns you're raising, and at this time I will order her release to Lake Magdalene for respite care with the detention review next week. Madam Clerk, what's her arraignment date?
Our next court date is in Division M for an ASIC arraignment for October 7th at 9 a.m.
So October 7th at 9 a.m. will be her next court date, and that should conclude the Carla Troubled case. Thank you, counsel.
Thank you.
Thank you, Your Honor.
All right. Good morning. My understanding is the second case is ready for today. This proceeding will be in person. Madam Clerk, what's our next case?
Our next case is Mark Foster, case 20 CJ 3223B.
All right, counsel, can I get appearances, please?
Erica Butts on behalf of the state of Florida. Attorney Patricia Dawson on behalf of Mr. Foster.
All right, good morning, counsel. I'll note that Mr. Foster is present, as are his parents. I don't see any victim present here in the courtroom, but I do note that the juvenile and his parents are both present. And counsel, have you had the opportunity to confer with your client pursuant to Florida Rule Juvenile Procedure 8.010F? I am hoping that you had the opportunity to confer with him and discuss with him his rights and the charges.
Yes, Your Honor. I had an opportunity before this hearing to discuss those issues with him.
Thank you, counsel. I reviewed the criminal report affidavit in this case. Counsel, have you both had the opportunity to review the criminal report affidavit?
Yes, Your Honor.
Yes, Your Honor.
All right, in my review of the criminal report affidavit, I reviewed the four corners and I do find probable cause. Let me ask counsel, does anyone have any objection to my finding of probable cause?
Yes, Your Honor. I have an objection. My client maintained his innocence. I do believe there are some ID issues. I do not believe that the affidavit specifically identified my client as a suspect in this case, so I will object to probable cause as to this CRA.
State of Florida, response?
Your Honor, based on the four corners of the CRA, it does state that this child was identified to be the one who committed this act. Therefore, we would ask that Your Honor do find probable cause.
All right, my finding of probable cause here doesn't change whether or not you may have a good defense to the robbery case ultimately, but at least based on the four corners of the affidavit, I will persist in my finding of probable cause, and I will note your objection for the record. Having determined that there is probable cause, I now turn to the detention risk assessment instrument, the DRAG. And Mr. Scurry is present from the Department of Juvenile Justice. Mr. Scurry, what does Mr. Foster score?
Your Honor, you scored 17 points.
And Mr. Scurry, what does that mean?
The normal falls, it falls within the range of secure detention.
All right, counsel, have you both had the opportunity to review the DRAG?
Yes, Your Honor.
Yes, Your Honor.
And do either of you have any objection to the calculation of the DRAG?
Not to the calculation, Your Honor.
No objection from the state.
All right, hearing no objection to the calculation of the DRAG score is fixed at 17 points. Counsel, what say you with respect to an appropriate resolution in this matter with respect to the idea of detention? What are we asking for here?
Your Honor, I'm asking for home detention, Your Honor. Like I said, this is an identity issue case, and I do believe it is a strong issue. Also, my client, is his first alleged, this offense is his first arrest. He's never been in trouble, he has no priors. He also makes all A's, and he's in high school, he makes all A's. He's a football star of the football team, he's the quarterback. Your Honor, his parents do want him home. He's in a loving home. His mother and his father both reside in the home together, Your Honor. They have been married for a very long time. Like I said, this is a young man who's never been in trouble before. And so I am asking at least for home detention with electronic monitor. So I'm asking you to please mitigate by 4 points, Your Honor.
All right, Ms. Butts for the state.
Yes, Your Honor. Well, I understand that this is this child's first offense. Based on the severity of the charges, the state would be asking that Your Honor uphold the 17 points and therefore hold this child in secure detention.
And this is a robbery with a firearm case according to the criminal report affidavit, is that correct?
Yes, Your Honor, and based on the statute, charges that are involving a firearm, the child is to be placed in secure detention.
Your Honor, you do have the discretion to mitigate, especially on the arguments that I have made, that is no priors, that he's a straight A student, that he lives in a loving home, there are ID issues, and you have the discretion to mitigate, and I'm still requesting you to mitigate for home detention and monitor. But he's still, the state will still, in a sense, get there secure. He will be monitored. And Your Honor, I believe no one leaves an active monitor so they will know where he is. And so we will again ask for home detention with a monitor.
Mr. Scurry, Ms. Dawson has asked about the electronic monitoring and active monitoring. Is there a difference between the Department of Juvenile Justice's monitoring system and that of the Sheriff's Office?
Your Honor, the Sheriff's Office monitors normally for the youths that are determined to be prolific juvenile offenders or youths that are at a higher risk if they are released. In this case, a youth with a firearm charge. Normally, a Sheriff's Office monitor may be ordered for that youth as opposed to a regular BI monitor with DJJ. There's also Sheriff's Office monitor. They may file a charge if that monitor is tampered with. So that's sort of the difference between the two.
Thank you. I have listened carefully to your arguments, and they are compelling, Ms. Dawson. The only problem here is although it appears to me that you are correct, this is the juvenile's first offense. It's a robbery with a firearm, and the criminal report affidavit is pretty, at least I understand that there is an identity issue that you're going to raise in defense, but beyond that, the facts themselves are pretty compelling. The core issue is whether for the court is going to be one sort of about trust. How are we going to do with this child? What can we do to keep him safe and get him back on track? And I'm not sure yet that he would be right for release at this time. I'm going to go ahead and order the 21 days, but I will invite you and Ms. Butts to confer, and if there's something that you all can agree to, we can bring it back up at a different time. I will also note this case involved the alleged use of a firearm. As part of my order today, I will order Mr. Foster possess no weapons, or I'm sorry, specifically no firearms or ammunition while this case is pending. So at least during the pendency of the case, no weapons or ammunition. Counsel, is there anything else that I need to address in this case other than setting the arraignment date?
Yes, Your Honor. The state would also be asking that this youth have no contact with the alleged victim, Allison Smith. And we would also be asking this child be ordered not to return to the offense location. The offense location is 123 Maple Lane, Tampa, Florida, 33526.
All right, thank you, counsel. And Ms. Dawson, anything else that you'd like to add? Or any objection to my ordering no contact with the victim and not returning to the offense location?
No, Your Honor, I have nothing to add and no objection to that.
Okay. All right, then I will include an order that that he have no contact with the alleged victim and they not return to the alleged offense location. Madam Clerk, what's the arraignment date?
His next court date is in Division F for a secure arraignment for October 8th at 8:30 a.m.
Thank you, Madam Clerk, and thank you, counsel.
Thank you, Your Honor.
Thank you.
So we doing the orders?
Hey, Erica, hold up for a minute.
Hey, what's up?
I really want to have a conversation with you regarding keeping him in juvenile court. Like I made the argument, you do have some issues with your case. He is the star of the football team. He's an all-A student. He's a good kid. He comes from a loving home. And if you can spend some time out to meet with me before arraignment and before you make a decision, a filing decision.
Yeah, let me take a look at the file and we can get together and discuss this further maybe sometime this week.
Yes, just give me a call, and anytime you're available, I'll be there.
Okay, sounds good. And hey, have you heard anything about this Florida Bar Juvenile Delinquency CLE going on?
Yes, you're talking about the criminal law section
Yeah.
seminar that they're going to have. It's going to be called, it's called Deeper Dive.
Oh, okay.
It's going to be a great seminar. I don't have the date at the moment, but when we meet, I should have it by then. And you really should register and tell all your friends to register also.
Yeah, that sounds great. Thanks so
Okay,
much.
then hey, I'll see you at the meeting and on the Deeper Dive.
All right, sounds good. Take care.
All right. Well, thank you all. That was the pre-recorded segment with hopefully some good acting. So you've heard a lot from the folks from Hillsborough County since we were filming here. We had a lot of local actors, and at some point, I certainly want to thank and acknowledge them for the time and effort they gave us to put that on. But the real purpose of it was, at least in part, to make this more interesting and to give some of our panelists something to discuss. So our first panelist up today is going to be Tanya Williams. Now, Tanya Williams graduated from the University of Florida, and she's been practicing law for over 24 years. She was an assistant public defender, and she formerly served in private practice. For the past 12 years, Tanya has worked as an assistant regional counsel for the Office of Criminal Conflict and Civil Regional Counsel in Miami. The whole part's a mouthful because the reality is she's the division chief. So, and she manages the delinquency division. Her duties include training and supervising her division attorneys and handling her own caseload. So I'm really excited to have her join us. She's also a board certified specialist in juvenile law, and she served for 6 years as a member of the Florida Bar's Juvenile Rules Committee. So I'm excited to have Tanya join us now. She's going to be the first of the three panelists to talk a little bit about what you just saw and to share some of her insights and wisdom. And so with that, Tanya Williams.
Good afternoon, everyone. And thank you, Judge Palermo, for your invitation. My role at this point is to reiterate, reinforce, and expound on some of the ideas that were raised by my colleague, Tony Julian, the first attorney who was consulted during the video presentation. So basically, Tony's presentation focused on the basics, terminologies. So one of the first things you need to know when you're handling a juvenile delinquency case is the proceedings are governed primarily by Florida Statute 985. So you need to become familiar with that statute. You also need to be familiar with Florida Rules of Juvenile Procedure. Now, what is a juvenile case or how does it start? Well, a delinquency case starts when someone, and that person has to be less than 18 years old at the time that he or she is accused of committing a delinquent act. And I say a delinquent act because in adult court, we have an adult who's accused of committing a crime. In juvenile court, we're going to have a juvenile accused of a delinquent act or breaking the law. So right there, here's the first difference between adult criminal court and juvenile delinquency court. Now, what happens once that person is accused? Well, through the presentation, they used the word criminal report affidavit. I'm from Miami. Usually we refer to it as an arrest affidavit or a complaint that's filed. And what happens is the child is taken into custody. Yes, for you criminal attorneys out there, that means the child is arrested. So taken into custody in delinquency court, arrested in adult court. Just a different terminology, but the same concept. Now, what happens once that child is taken into custody? Once the child is taken into custody, just like in adult court, within 24 hours, that child must be presented before the judge. In adult court, that's your bond hearing. In juvenile court, that's called a detention hearing. Now, let me pause here because I guess what I wanted, and I should have pointed out, is that the primary focus or purpose or goal of delinquency court is supposed to be rehabilitative. And I guess I've been a defense attorney for too long, so I'm a sort of a cynic because sometimes I don't feel like that's what's happening, but that is the primary goal, rehabilitation. So your job as a defense attorney is to maybe sometimes remind the players, and I'm not going to go too much more into that, but yes, primary goal, yes, you want to keep the community safe, but it is to rehabilitate the child, to provide the child with services to ensure, to maybe correct that behavior, whatever that behavior is. Now, back to the detention hearing. As I said before, that happens within 24 hours of the child being taken into custody. And like I said, that's similar to an adult bond hearing. But here's the difference. Adult bond hearing, we're talking about usually monetary bond or forms of release. In juvenile court, detention hearing, there is no monetary bond. So basically, what are you looking at? You're looking at custody release, which is similar to being released on your own recognizance, except the child is custody released to his or her parent or guardian. Another option would be home detention. Home detention is similar to house arrest. It can be with or without a monitor. And the third option would be secure detention. I'm not going to go into how it is determined whether or not the child gets custody release, home detention, or secure detention, because one of my colleagues will be discussing that shortly. But those are your options. Secure detention is similar to jail, but it's not jail. Because the main difference is the child is receiving services while there, and the child is able to go to school. In Miami-Dade County, you have Miami-Dade Public School that's teaching the kids in secure detention. So while the child is detained in secure detention, the child is going to school. Also note that here is a big difference. If the child is detained, whether or not it's home detention or secure detention, the law says the child cannot be detained over 21 days. So at 21 days, the 21st day, the child should be released. And usually there's a self-executing order that was prepared at the bond hearing, at the detention hearing, and the child is released from secure detention or taken off home detention. Now, there are some exceptions to that 21-day rule, but right now for the basic and generally speaking, it's 21 days. Exceptions may be in a direct file case. So know that. And usually they may give you 9 days if you have good cause, but it's 21 days, guys. So when your child is placed on in secure detention or on home detention, no, tell your child after 21 days, he or she will be released, custody released. Now, at the detention hearing, you will also receive a notice for the next court date. The next court date is similar to what you have in adult court. It's an arraignment. Now, what's the difference between an arraignment in adult court and juvenile court? Well, the first and primary difference is the charging document. The charging document, as you know, in adult court is an information or it might be an indictment. In juvenile court, the charging document is called a petition. And the way the caption is also written, it's different. In adult court, it's state of Florida versus whomever, the defendant. In juvenile court, it's in re the interest of child's name, child. Yes, the child is referred to as a child and sometimes as a respondent because you have a petition, petitioner, respondent. But the child is called, in juvenile court, it's a child. Now, once you have, so at the arraignment, the petition is filed. It is your job as an attorney, a defense attorney, you should review that petition to make sure that there's a prima facie case laid out there, okay? That's one of the, but make sure you review it, make sure you explain it, the charges to your child. At the arraignment, you're gonna enter that plea of not guilty, demand discovery, and now you're gonna be tempted to say and set it for trial. Because that's what happens in adult court. And frankly, that is what happens in juvenile court, except we call a trial in juvenile court an adjudicatory hearing. And it's a non-jury trial. It's a bench trial, but it's a trial because the child has the same constitutional rights as that defendant in adult court. It's the same rules of evidence. It's the same statutes, and it's the same burden of proof beyond a reasonable doubt. So the case is set for trial, and now you have your adjudicatory hearing. Now, one of the things I do want to, and I'm going to pause here for a second, is to impress upon you, make sure that you are talking to your child, that you're in constant communication with your child. And I say your child, note, as a private attorney, you're more than likely hired by the parent or guardian, but never ever forget that your client is the child. And this is not a case of best interest of the child. Your child is your client, and you need to listen to your client and do what your client wants. And you say, well, the client is a child. Well, it's your job to make sure the child understands the law, understands the defenses, understands what he or she's facing. That is your responsibility. So now between your arraignment and now you're getting ready for that adjudicatory hearing / trial, make sure you're in, like I said, that you've spoken to that child and you've gone over the defense and the different options. He has a right to go to trial. If he doesn't want to go to trial, he has a right to a plea. Same as in adult court. Now, if you go to trial and the child is found guilty at the trial, there is a different terminology that's used here also. So please note, in juvenile court, when a child is found guilty, it's not considered a conviction. And an adjudication is not a conviction. Like I just used the word is called an adjudication. So he may be adjudicated delinquent, but for all purposes, well, not all, it is not considered a conviction, even though in some circumstances, it may be treated as a conviction. And I guess it will take me a little bit more time if I was to go into all of those circumstances. But note, if the child was to go out there and someone says, have you been convicted of a felony? And yes, the charge he had in juvenile court was a felony, but the answer to that is absolutely not, no. Oh, and something I also needed to mention about the trial. There is also a big difference in the speedy trial period in adult court versus juvenile court. Adult court, I believe in felonies, it's 175 days to trial, 90 days for misdemeanor. But in juvenile court, it's 90 days. 90 days from when the child is taken into custody, or not if the child was not taken into custody, 90 days from the time a petition was filed and the summons was received. So note, just remember that. Now, if you go to trial and the child is found guilty at a trial, what happens next? Well, it's like adult court sentencing, except in juvenile court, we call that a disposition hearing. So a disposition hearing is similar to a sentencing hearing in adult court. In juvenile court, though, instead of dealing with the Department of Corrections, we have the Department of Juvenile Justice, DJJ. They prepare and submit a document called a PDR with recommendations for the court. Those recommendations usually include sanctions and services that the child will need to complete. And in preparing that report, the department often look to the risk, accountability, and the needs of the child. Because again, remember, juvenile delinquency court is about, the focus is about rehabilitation more so than punitive. So rehab. So you'll see things like counseling on there. It may be drug counseling, it may be family counseling, but there will be some counseling. It could be individual counseling. They don't say exactly what it's for. Then there'll be community services, curfew. That's if the child is placed on probation, because at the disposition hearing, there are several sanctions or that could be imposed. Frankly, the child could get a judicial warning. And I can tell you in Miami-Dade County, it does happen. You just have to know how to make that argument for a judicial warning, because you can get that, do not do it again, which I love. Or the child can be placed on probation, and I'm sure you know what that is. And then the other option would be a residential program with the Department of Juvenile Justice. But the sanctions I mentioned before, such as curfew, community service hours, counseling, restitution, those would all be imposed as a part of a probation recommendation. If the child was committed, then those services would occur at the end when the child is on what we call conditional release. Now, I said this before, and but it bears repeating. Your client is the child. So when you sit in that interview with the parent, I know it's going to be difficult, but somehow you have to let the parent know and the child understand that you are the child's attorney and that you're there to advocate for the child's wishes. So when that parent will sometimes tell you, I want that child in the program because he or she isn't listening, more than likely your client, the child, doesn't want that. And so you have to advocate for your client's needs. The last thing that was on the presentation that I saw, and I'm just going to touch on it briefly, is I believe Attorney Dawson had mentioned a concern to Attorney Julian about the gun case, a robbery with a firearm, and she was asking what to do, how to keep the child in juvenile court. I'm going to touch on that briefly. The child in this case was 16 or 17 years old, and she mentioned him being a good student in that. The one thing I want to impress upon you is, as soon as that child is taken into custody, and if you're present at that time or you're present at the bond hearing, but as soon thereafter as you get an opportunity, you need to be reaching out to the state. Usually within that 21 day period, you need to be reaching out to the state on the phone, in their office, email, whatever. And what are you going to be telling the state attorney? First, you're trying to convince them to not file charges. That's what that's the first thing you should be trying to do. But obviously, if it seems like they have a case, then you're going to try and tell them, listen, if you're going to file charges, file it in juvenile court, and here is why. And then you try to give them some mitigating reasons as to why they should do that. For example, in this robbery by firearm case, maybe this child was not the person with the firearm. Maybe the child was merely present. So you want to look at some of those things to see if you can maybe argue that he was less culpable than somebody else, you know, and presenting any sort of other weaknesses you may see in the case to encourage the state attorney to keep your case in juvenile court. And at least I'm saying this because I know that's what we do in Miami-Dade County. I'm not sure what's done around this throughout the state, but in Miami-Dade County during that 21 days, you need to be contacting the state, and it does make a difference. It absolutely does. Okay. And that's it for me. I'm gonna pass it back to the judge. And I guess if you have any questions, we can talk about it at the end.
All right. Well, thank you so much, Tanya. And I appreciate you sharing your insights. So now you all have heard the pre-recorded portion, Pat and I from Hillsborough County, and you've gotten here from Tanya in Miami. We're going to take a walk north across the state to Brian Coughlin. If you will turn on your video, Brian is a director of the Bedell firm in Jacksonville. So his practice focuses on matters of criminal justice, and he is currently a member of the Juvenile Court Rules Committee on the Florida Bar, and he's the former chair of the Professional Ethics Committee. And so Brian is on the board of governors of the Jacksonville Bar Association. He received his undergraduate degree from the University of Michigan in 2000 and a law degree from the University of Florida in 2003. He was previously an assistant state attorney in Jacksonville before he went to the Bedell firm, where he works with, among others, Hank Cox and also my colleague and friend, David Barksdale. So with that, let me turn it over to Brian.
Thank you, Your Honor. It's great to be here with everybody and to be on a panel with two other very accomplished lawyers. As you said, I am on the Juvenile Rules Committee. I've been on the committee for over a year now, and I see at least one other member of the committee is with us today in attendance. What I'd like to do before I talk more about some video-specific matters is diverge a little bit and raise the fact that when I came onto the Juvenile Rules Committee, the committee was contemplating a rule that would have imposed minimum standards for attorneys in delinquency cases. And if the rule would have succeeded, of course, it would have been the obligation of any attorney who wanted to take a delinquency case to do a number of things. I don't believe that that is actually going to be approved. I think it was considered for actually a couple of years, and I think it will fall short, but it underscores how important it is for lawyers who are going to get involved in children's lives in these delinquency cases to take it seriously, to think beyond the general competence rule that's in the Florida Bar Rules. And what I'd like to do is tell you what that proposed rule would have required so that everyone has a sense of some baseline knowledge that is needed to do this kind of work and to do it adequately, if not excellently. So the purpose of the minimum standards, of course, was to make sure that lawyers were reasonably skilled in the specialized practice of juvenile representation, and it is specialized. What would have been required are a couple of general things. Of course, you'd have to be familiar with Chapter 985 of the Florida statutes and have read the Florida Rules of Juvenile Procedure. Quick aside, when you go to file your pleadings, take a look at them. Don't cite the rules of criminal procedure. I know we all sort of rush through those things, but it's a good first step. Let's make sure we're citing the right body of rules. Lawyers would have had to be familiar with the practice and procedure of juvenile courts in the jurisdiction, have been familiar with and experienced in the utilization of expert witnesses and evidence, including but not limited to psychiatric and forensic evidence. Lawyers would have been required to have read Florida guidelines of practice for attorneys who represent children in delinquency proceedings. These were a set of guidelines approved by the Florida Bar Standing Committee on the Legal Needs of Children, and those guidelines are posted on the bar website. This rule would have required at least 6 hours of observation in juvenile court and at least 8 hours of juvenile law CLEs approved by the Florida Bar. So no small devotion of time would have been required for people to take these cases. And again, I think the concept is important for all of us to know that if you practice criminal law, it's not the same thing. You can't just roll into juvenile court and think that you're going to use the same phrases and handle cases the same way. Now, with the video, I have been asked to speak about the second phone call that Pat placed to Dominique, and Dominique raised a few issues. Of course, she restated that the goal of this is rehabilitation, but let's point out the obvious. While rehabilitation is supposed to be the goal, the juvenile court system is still an adversarial system. And while it's difficult sometimes to keep those two concepts together, I like to walk into most juvenile cases with the sense that everybody's kind of going to have a common goal about putting the child back on the right path. If you've got a very serious case, firearms, weapons involved, obviously there may be more butting of heads. But in a lot of cases, I think you start from the premise that the stakeholders involved in the case and the two parties are going to try to work together to find the right outcome for the child. In the first fact pattern in the video, it was a familial battery, and the child had no prior offenses. That to me sounds like the kind of case where if the state could prove it, you would pursue a diversion type outcome, a diversion program. And those programs are different around the state. Here in Jacksonville, we have things like the Youthful Offender Program. We have the Juvenile Diversion Alternative Program. We have Juvenile Drug Court. And we actually have had a diversion program that is specifically for children who have either participated in or witnessed domestic violence. And so assuming the case could be proven by the state, I think my first step would be to ask them to consider a diversion program, which would allow the child to complete the program. And if successfully completed, those charges would be dismissed. And you wouldn't have to worry about all of the technicalities that Tanya touched on about convictions and the like. And so it seems to me that diversion is very often a goal in the cases that I've handled. Now, the second case of our video, obviously much different. And it was a robbery with a firearm. And the goal, as Tanya so eloquently stated, the first goal is let's keep the case in juvenile court. The statute that applies to direct files by the state attorney's office is 985.557. And in our fact pattern on the video, the child was 16 or 17 years old, which under that statute, the state has the ultimate discretion to file that in adult court if they think the circumstances lend themselves to that. And I'll just underscore what Tanya said. I know we all have deadlines and we have cases that we got to pick up and run with, but juvenile cases are an extreme example of that, because decisions that can be made about a child's life within a few days can affect them for the rest of their lives. And direct file is really the best example of that. So if you're going to take a serious juvenile case and it's one that may be direct filed, you're going to devote the next several days to talking to teachers, to talking to clergy members, talking to other adults in the child's life, talk to siblings, and you're going to have to put together a packet of mitigation. And you're going to have to communicate with the state attorney's office. And you may need to trouble supervisors and just keep going up the ladder to try and effectively avoid the child being brought into adult court because of all that flows from that. If you were to look into some of the research on brain development in children, you'd realize that children are more prone to emotional decision making. They're more unable to anticipate future consequences. They're impulsive. They're likely to engage in risky behavior. They're unable to fully consider all options in a situation, and they're susceptible to peer pressure. All of these things you have to really beat on these facts and beat on that this is a child and that rehabilitation is the goal, and the child has a chance to be rehabilitated despite what might be serious facts and poor decision making. So I will now pass it along to the third member of our panel. I appreciate everybody's attendance, and if there's time, I look forward to answering any questions that you might have. Thank you for having me.
Well, thank you, Brian. I appreciate you coming and sharing your perspective. And it'd be great, the more competent the counsel are as they appear in delinquency, the less likely we're going to end up with a competency-related rule. So hopefully programs like this and the future program that the criminal law section is going to put on will help. But the next person who's going to speak to you today, we're going to take our walk across the state. I couldn't get anybody in Key West, but I got somebody in Pensacola. And in fact, I'm excited. It's Katrina Saggio West in Pensacola. So Katrina graduated from Florida State University College of Law in 1991. She previously practiced with ACA, but I think relevant to why we're here today with Katrina is she's practiced juvenile law for the past 25 years, including with the Department of Juvenile Justice. For the past 20 years, she's been an assistant state attorney in the First Judicial Circuit of Escambia County in the Juvenile Division. And I think more importantly to the discussion today, Katrina is the author of Chapter 4 of the Florida Bar's Juvenile Law and Practice Monograph. She wrote the section, Delinquency Proceedings Before Petition. And so with that, let me ask Katrina to unmute and to join us.
All right. Okay. Yes, Judge Palermo had mentioned the chapter that I wrote in the Florida Juvenile Law and Practice book. I do not get paid for this. So I would strongly recommend that you get a copy of this. You will not be able to read it, but this is a fantastic and informative book if you're just beginning in the practice of juvenile law. I did write Chapter 4, which is the delinquency proceedings before the petition, which if you're just entering the practice, handling your first juvenile case and going into juvenile court, it's very informative. It talks a great deal about the difference between juvenile terminology and adult terminology, the rules, the rights, the standards with searches and whatnot. A good portion of what I was going to talk about seems to be covered by everybody else. However, I do want to make clear that the juvenile provisions are clearly statutory. There are a number of rights that juveniles do not have a right to. One of those, they do not have a right to bond. They also do not have a right to a jury trial. One of the things I see a lot with new attorneys coming to juvenile court is I will get motions for motion to reduce bond. There never has been a bond, so that's basically a wasted motion to file that. Be more appropriate to file a motion to release from secure detention, home detention, what have you. So just some terms that I notice a difference of, and I think a lot of this varies around the state. One thing is we do not use the terminology of a warrant. We use an order taken to custody. Again, we have no bond. We don't use the term jail. We use the term secure detention. We also have intensive home detention with or without a monitor. And we don't use the term arrest. We use the term taken to custody. I think that the first thing, if you're getting a juvenile case that you're going to have to deal with for somebody who meets detention criteria is going to be going in and handling the detention hearing, as you saw in the video. When a juvenile comes in, instead of assessing the case for bond or setting bond, what you're going to have is a detention risk assessment instrument. And based upon the scores and the backgrounds, the presenting offense and all of that that's included is going to determine whether a child has to be straight released or whether they have to be put on home detention or secure detention. A judge is not bound by the score. They can vary from that. They can consider mitigating factors. They can consider whether the child wants or the parent wants the child at home. All of those factors. One thing I noticed about the first case with the domestic violence case, domestic violence is a little bit different than a lot of the charges because the standard to look at is whether the parent is afraid or wants the child home. There has to be information provided as to whether the parent wants them home. if the victim, the parent, sibling, whatever, is afraid of having them in the home, then they need to look at respite care, which is a lot of times done in the staff secure shelters, or to be looking at an alternative placement with an alternative relative, a friend. But if they are placed on detention status, then they are going to follow the rules for juvenile cases, which is going to trial within 21 days or being released from detention status. Now, in Escambia County, things are a little bit different. I'm not sure if it's done any other place in the state. I believe Santa Rosa County does follow it. But we actually do our trials within 21 days. When a child comes in for their detention hearing, we also call that an arraignment. We try our best to arraign them at that time. So for any of our cases, we go to trial within 21 days. So they have their detention hearing. We, at some point in the morning, have filed the delinquency petition. And then when they come in for their detention hearing, we not only address the detention status, but they also decide whether they're going to enter their plea of guilty or not guilty. Now, we used to do that. We'd have the detention hearing and they'd be set for arraignment within that next coming up week. In order to avoid losing too much time on the 21 days, we started arraigning at the detention hearing. So juvenile cases, if they're detained, the trial has to be commenced within 21 days. If they're not commenced within 21 days, unless there's good cause, then they're supposed to be released. Now, recently we had a hurricane, courts were closed, couldn't have detention hearings. So some detentions were continued beyond the 21 days due to the fact that there was good cause. The other thing that we do at that hearing is, if it's a first offender, we're going to make the decision of whether to do a non-judicial action or to go ahead and proceed with filing the petition and going to trial. We do all of our cases within 21 days. An additional 9 days is permitted if it's a violent second-degree felony or above. That would be our sex offenses, aggravated batteries. A lot of those cases are, we try to get that additional 9 days. The reason for the sex offenses to be within the additional 9 days is you have to do your notice of child hearsay and all of that other information. Those cases take a little bit longer. Now, to be able to do this requires a great deal of cooperation from all the parties involved. It involves law enforcement having to be able to come in within 21 days, getting DNA back, being able to get your testing on your controlled substances, having secretaries that are able to push those petitions out fast and the discovery out fast. We have a 24-hour rule in our office, which means when we have a case come out of detentions or arraignments, we have to have that discovery done, not within the 5 days, but we have to have it done within the 24 hours. So we try to work all of that in there. It is a little bit different. It seems like it would be a little bit harder. I like it. It gets the cases in and out quickly, which I think is important for juvenile law in terms of they're not sitting in detention, their case isn't pending, it moves swiftly. And I think that that's very, very helpful to the youth to be able to get these through faster. Another thing that I noticed from different areas around the state are just to talk a little bit about the non-judicial actions. I heard, I think the terminology is different from adult court. You have your, the adult, you may have pretrial diversion. At least in Escambia County, we don't use the term pretrial diversion. We use the term non-judicial action. And as part of a non-judicial action, you may have different programs. You may have arbitration, you may have civil citation, you may have teen court. So there are other factors that are, or other programs that can be included instead of filing a petition. Your first offender that's coming out is most likely going to get a non-judicial action. Another terminology that I heard used previously was a Walker plan. At least in Escambia County, we don't use the term Walker plan. We use the term advisement. An advisement was where they enter either a no contest or a guilty plea. They're given sanctions within that are very similar to probation. But at the end of that time period, they have the ability to have the case either dismissed or null prossed. And that's something that we try to do on a lot of our kids that go through the first time in judicially. So I'm going to go ahead and turn it over from here. Please take a look if you're a new practitioner at the Florida Juvenile Law and Practice book. Most prosecutors are willing to talk to people and explain some of the differences. So they're always a good person to call before you go into juvenile court for the first time. I'm going to turn it back over to the judge.
All right. Well, thank you so much, Katrina. I appreciate it. And I got to put in a plug. It's one of the monograph is one of the books that I acquired when I came to join the delinquency bench. So I'm going to tell you now, the time is 1:23. We might have time for a question, but we're really short. As the panelists found out, I'm an early is on time, late person, and that includes for all the participants who came and joined us today. For the ones who came and joined us today, I want to express my my personal gratitude. I hope that you found this useful or got something good out of it that'll help you be more effective representing juveniles. We want to see you appear more competent and to be more confident when you're in delinquency courts. So the one thing I'll tell you is I also want to just take a moment to acknowledge all the people who participated in the pre-recorded segments. Erica Butts is an assistant state attorney in my division, and I actually got to swear her into the Florida bar. So I haven't gotten to marry anybody yet, but I did get to swear her in, into the state attorney's office and maybe in the Florida bar. And I was excited about that. Dominique Sellerin is at the public defender's office here in Tampa. She's she's a felony level attorney at the public defender's office, but she was training a lot of the people who appear in delinquency courts here in Tampa. And Travis Coy is the chief of the juvenile division. He's been a great friend. He's also, among other things, the president of the Georgia Edgecombe Bar Association and the vice president of the Tampa Bay chapter of National Black Prosecutors Association. Travis is fantastic. Tony Julian, also another friend. He was at the state attorney's office, he was a prosecutor for 25 years. He was also licensed in New Mexico and with the Navajo Nation. So in addition to being the deputy chief of the juvenile division, and then Amanda Mendez, who I can't say enough good things about. She was a public defender assigned to my delinquency division, and really it was a heartbreak when she was promoted. So outstanding attorney, and I was really grateful to have her. But you've heard a little bit from attorneys from across the state of Florida, from Miami, from Jacksonville, from Pensacola, and also from Hillsborough County. And there's a lot of lead up, a lot of extra work that went into this for them. And so I hope they know that Pat and I are very grateful to Tanya and to Katrina and to Brian for being willing to give their time and insights. So we hope that this was helpful to all of you. And it really, it matters to us that you all are excellent attorneys and doing well, because we want to see the children who appear here in delinquency court, that they get the best representation they can. It's the only way to really do justice on both ends of these cases. I do also want to just take a moment of personal privilege to thank Jenny Dormey from the Florida Bar Criminal. She works in the criminal law section. She's the moving force behind the scenes that's made all this happen. And to the amazing Scott Fingerhut, who handles all CLE for the criminal law section. Last thing, and then I'll stop, is one of the attendees today was Rosemary Armstrong. I don't know if you've noticed, but it's hard sometimes to have parents involved, to have them join the cases, which you really need the parents for the key moments in a delinquency case. Not all parents are available, not all parents are on it. Rosemary Armstrong runs Crossroads here in Tampa, and she manages the volunteer attorney ad litem program that makes all the difference for actually being able to to do effectively delinquency cases. So I just call this a brief thank you to Rosemary Armstrong for all of her enormous contributions to the delinquency system, especially here in Hillsborough County. And of course, I don't know if anybody noticed, but also we had two Florida Supreme Court justices with us today. John Coriel, who was a former member of the U.S. Department of Justice, where I once worked. He was in the Southern District of Florida. I was in the Middle District of Florida, and also Justice Peggy Quince, one of our hometown heroes. So it was great to have both of them participating with us today. And frankly, there are so many amazing people who were participants today. An awful lot of you probably should have been panelists, but the reality is I was incredibly lucky, and I'm incredibly grateful to have Tanya, Katrina, and Brian join us today, to have all the volunteers on the pre-recorded segment, and even better to have Pat Dawson keeping us all on track and making this actually happen. So she's been an amazing friend over the last 20 years. So with that, I only call back Scott Fingerhut. We still have just about 2 minutes left.
Well, to reiterate a little bit of what you just said, Judge, thank you to all the presenters, performers, lawyers, to all the IT folks you put in motion to get that video done. One of my favorite parts, by the way, was how quickly the most helpful people in the world answered the phone on the first call within 2 rings. I thought that was magnificent. To you, Judge Palermo, the numbers here today, we were pushing 200 attendees today. That's a testament to our need and desire to get better at what we do for our children. And thanks to the 200 of you who joined us. We hope you learned something. We hope it was helpful, and we hope you pay it forward. The course number, once again, 4193, and Jenny will be sending out the video link, the accreditation forms, and of course, to all criminal law section members, this CLE will be free. Probably forever, we'll leave it up there, but for 18 months, it's good to get CLE credit for and from. Some CLE on the horizon from your criminal law section you may be interested in. Next Friday, October 23rd, as we continue our Experts in Advocacy series, Ed Page from Carlton Fields. He has a 3-part series that he calls the Deposition Notebook. Great tips. It'll continue into November and December. We hope you attend that. That's at noon on October 23rd. Noon on the following Friday, October 30th, the day before Halloween. Our Attorney Wellness 3rd webisode, Our Gift to Ourselves, with Dr. Weinstein from FLA and Molly Paris from FLA, just talking to us, checking in and seeing how we're doing. On Friday, November 13th, starting at 8:55 in the morning, is our annual criminal law update. Great updates on jury selection and DUI and immigration, a state of the criminal justice address from Judges Soto and Saifi, Chief Judge and Administrative Chief of the Criminal Division in the 11th Judicial Circuit. But the big moment of that seminar is Justice Anstead over the lunch hour, talking to us about life and law and his take on where we are in the world these days. Also, our membership committee puts on a great event monthly called Connect, CLS, Criminal Law Section Connect. It's conversations, not for CLE credit, but wonderful times to get together. November 6th at noon, are Judges Andrews, Della O, and Ward from the 6th, 11th, and 13th Judicial Circuits, respectively. Tune in for that. Our Rule 3.113 compliance video, our latest one, recorded by criminal defense lawyer Dennis DeVlaming on the West Coast. That's been posted to our site. Safer at Home with the Judges Harris. The next installment is coming up next month. And of course, as Judge Palermo will tell you, sort of the continuation of this event, the deeper dive into more intricate parts of prosecuting and defending and judging juveniles in delinquency court is coming. Join us. Look around the world. Has there ever been a more important time to make positive, substantial change around us, to know we've gone home at the end of the day feeling like we've done more good than harm? How a society treats these people, these juveniles, our outcasts of all shapes and sizes, says the most about the type of society we are and are destined to become. And with that, floridabarcls.org, floridabarcls.org. Thanks for being with us today, and we'll see you soon. You guys want to hang out for a sec?
If you want to.
Yeah, sure. Sure. The chat was very active.
It was hard to follow and to keep up with, though, and to answer some questions.
No date yet for the deeper dive. We're still working on that program, but as soon as we have it, we'll send it out. I'm just looking at the chats. If you want to know in advance, just send me an email. And as soon as it gets set, Jenny and I can let you know.
Tanya, you were marvelous. I sat there and crossed through half my notes because you had covered everything. You were awesome.
Yeah, good job.
I had to kind of focus afterwards.
And of course, Justice.
although you're not as good as unmuting yourself when you're
she has some
talking.
I tried to stick to the script.
You were
fantastic. It made sense to do it that way because I was like, how else are you going to present this? So you sort of walk them through and you do the comparison. They'll know it and they'll get it.
You were fantastic because I was like, she covered this already. Okay, she got this, and it was so concise.
I almost touched on the Dre, and then when I watched the video again, I said, oh, they didn't go into the Dre, so let me just mention the types of relief.
It's so complicated right now, though.
Yeah.
You know, the new one is so complicated. The old one was so much easier to follow.
You guys go to trial in 21 days?
Yes.
Listen, I cannot tell you the last time that has happened in Miami. We're relieved. The child is.
Your caseloads are huge.
Where
There's no way you could.
Sorry to interrupt. Where did Judge Palermo go? Did he have a calendar to go do or something?
He said he had a docket to follow.
Yeah.
Okay. Well, I just wanted to thank you guys for doing this. Right, as folks slowly sign out.
Scott, I hope you enjoyed it and that we're proud.
Of course. And if you're reading any of the comments, many people are saying this was the best CLE that they've attended for a while, and the video was a great component. We told them it was going to be nuts and bolts, and you were going to be able to learn if that was what you wanted, and they did. So, mission accomplished.
And thank y'all, everyone. Y'all did a wonderful job. I'm gonna be calling y'all. Call a friend when I get a Juvenile.
You can call me anytime.
Okay, or email because I may need to call y'all.